Hello, my name is Esther Waweru. I work at Equality Now's Africa office as the senior legal advisor working on legal equality specifically. My role entails working on the African continent with respect to setting of normative standards, adoption of national laws and reforming those in conformity with regional human rights instruments, and in particular, the protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, most commonly referred to as the Maputo Protocol, which is the primary instrument on women's rights on the continent. I also coordinate a coalition of 72 organizations based in Africa that work on promoting the Maputo Protocol. And these organizations are based in over 30 countries on the African continent. This coalition is known as the Solidarity for African Women's Rights Coalition, or the SWAG Coalition. I'm very happy to be here. Family laws is one of the issues that we have been getting civil society organizations on the continent to focus on and to have a more collaborative and coordinated approach on that campaign.
Hello, I'm Hyshyama Hamin. I'm the campaign manager for the Global Campaign for Equality in Family Law. It's a joint campaign that launched in the March of 2020, right in the heart of the pandemic. And its founding members are Equality Now, ACT Church of Sweden, Musawa, CLADEM, which is the Latin America and Caribbean Committee for Defense of Women's Rights, Muslims for Progressive Values, SOAR, so Solidarity for African Women's Rights Network, represented by FemNet, Women's Learning Partnership, and UN Women. So 8 really founding and amazing organizations doing work across multiple regions. And really the vision and the goal of the Global Campaign for Equality in Family Law is equality for all women and men under the law in matters relating to family, regardless of culture and religion. And we're really hoping to bring family law up as a priority global issue, both in the women's rights space, in the human rights space, and just as a foremost issue that governments, particularly with discriminatory family laws, need to consider, think about, and really accelerate reform on. And that is really what the coalition is, and the coalition and the Global Campaign is working towards. As far as we know, our working definition of family law is that family law refers to a body of statutes, rules, regulations, court procedures, along with customary and uncodified laws and practices that could be based on religion, that could be based on tradition, that could be based on, legacy laws that govern relationships within family units. So just to sort of also look at what some of the international standards on family law are, it includes areas that are that are covered by but not limited to Article 16 of the CEDAW Convention, which includes rights of women and men entering into marriage, rights of women at the time of divorce, custody, guardianship, property rights, equal inheritance, and so on and so forth. So basically, as far as we know, our working kind of formulation is that there are 3 main types of family laws. So customary, civil, and religious family laws. And Esther, maybe you want to tell us a little bit about the difference between some of those 3 main ones?
Thanks, Hyshyama. So yeah, usually when we talk about civil family laws, we're talking about laws that have been codified, meaning that they exist as written statutes, either in the form of a constitution or a specific law on family issues. And so this exists, and we've seen a lot of countries, especially in the last decade or so, adopting family law specific legislation. And so therefore, the way of enforcement of civil family laws is usually through the judicial processes, and most of these laws then view marriage as a legal contract that is enforceable by law. Customary laws, on the other hand, are purely uncodified. They evolve with time. They are not static, depending on the specific region or community or country in which they are practiced. They're mostly defined by the communities and are passed on from generation to generation. With the passage of time, obviously, they do evolve to cater for the different contexts of a particular society or group of people in a community at any given time. They are purely not codified, not written down, and sometimes draw a lot from religious family laws or practices. And so they do differ from community to community. And are not, very, cannot be said to be very specific to a particular country because of the different units or different communities that exist in there. They would then not be enforceable primarily through judicial processes, but through traditional practices or customary practices, I would say. Religious laws, on the other hand, as well, can either be codified or non-codified, meaning that they are either written down or not. And they are often tailored around or crafted around a specific religion, drawing from lessons past or experiences within different religious groupings, and they do apply only to that specific to members of a specific religious community or religious group. They could be Muslim, Christian, or even Hindu in some instances. So that's sort of how we see the different groupings of family laws as civil, customary, or religious family laws. And just to say that at any given point, it's very possible that the three can be applied with respect to one person. And so therefore, this then means that we get into the realm of what we call legal pluralism, which is, again, very complicated in terms of which applicable law would be used in any situation. And that in and of itself is quite a big challenge when we're speaking about equality in family law.
I think also what we're seeing is that in one particular context, in one country alone, on marriage and divorce, different laws apply differently to women. For example, women in a minority context may have a different application of law that denies them of certain rights that perhaps women in the majority communities may not be impacted by, and vice versa. Sometimes women in minority communities may have particular legislation that protects their rights, whereas women in majority communities may not. So I think it also interacts a lot on grounds of minority and majority communities, also a number of different of what is covered, what they are covered by, whether constitutional guarantees of equality apply to different communities within that particular country. So there's a lot of overlaps and intersections that we're seeing. And this came out quite a bit at the recent Africa Regional Network on Family Law, right, Esther? What would you say were some of these observations some of your observations in terms of these like intersecting overlaps between, and particularly in Africa, customary, civil, and religious family laws are so intertwined. What else came out in terms of lessons and things from the workshop with regard to this?
I think the biggest challenge is, of course, determining which is the best law to apply. Because you're dealing with different issues at any given point. So, for example, if you're looking at establishing the existence of marriage, for instance, that has been initiated through customary law, and then you're going before a civil court for dissolution or even distribution of matrimonial property, you find that then the starting point would be at the point of establishing whether a customary marriage or what was previously referred to as a common law marriage exists. You would have to delve into the customary laws and practices of the people who are appearing before the court, right? And so you find that the court would have to address itself first to the customary laws that are applicable to the two individuals that are appearing before it, before then now coming into application of statute law, with regards to, for example, dissolution of the marriage and distribution of matrimonial property. And I think the other area where we're very likely to see the intersection or the confusion in the application of the three types of marriages is, of course, where you have a mixed marriage, for instance, between, so it's a civil marriage, but you also have one party particularly wishing to apply or be subject to religious laws. And so when it comes to matters of personal law, as we all know, in many statutes, they actually do say, for example, in Kenya, they do say that the statute laws apply, but in matters of personal law, then Muslim law would apply. So what happens when you have a mixed marriage, for instance, one party is Muslim, the other is not, and they're before a civil court. So what we have seen, even out of decisions that are coming from the courts, is that there is always one disadvantaged party, and more often than not, unfortunately, it is the woman, particularly when it comes to distribution or sharing of matrimonial property, because then the default, especially where religious laws are concerned, is that then takes precedence over codified law. And so, these things continue to perpetuate themselves in various ways. And I think for me, in countries where laws are not codified, and particularly where family law or even equality in family law is not entrenched in the constitution, it's quite difficult for parties who are coming to the courts for justice to be able to get equitable justice in that regard. I would, of course, contrast it to where countries that have constitutional supremacy, if you do have reference in the constitution with regards to family law, equality in the family, then that's always a very good reference point. And you can sort of, you invoke the constitution in that regard to supersede all the other codified or non-codified laws, except, as I said, in most countries where religious laws are concerned, then the default is always to revert to that.
So I also want to bring an example here of like a contradicting example from Sri Lanka. We also are seeing contexts where Sri Lanka, being a Muslim minority country, Muslims comprise of only 10% of the population. They have their own Muslim personal law, Muslim Marriage and Divorce Act, which governs marriage and divorce matters for citizens. So their Muslim family law is actually codified. And for the rest of the community, rest of the country, so all the rest of the citizens, they can follow the general law, the General Marriage Ordinance, which other communities like Tamil communities, Kandyan Sinhalese communities, the Burgher community can all marry under. But two Muslims marrying in Sri Lanka can't marry under the Muslim marriage and can't marry under the general marriage law because they're pigeonholed into marrying under the Muslim Marriage and Divorce Act. And in fact, we don't have a constitutional guarantee of equality because there's a provision in the Fundamental Rights chapter of the Sri Lankan Constitution, which is, a colonial legacy clause, which says that all existing written and unwritten laws, or Article 16, right? All existing written and unwritten laws shall be considered valid and operative, notwithstanding any consistency with the preceding provisions of this chapter, which are fundamental rights. So regardless of the fact that some of these laws written prior to the Constitution may discriminate against women or certain, members of a community, and may violate fundamental rights provisions, they are still considered valid and operative, which means that the Muslim minority community in Sri Lanka does not have constitutional guarantees of equality either. So I think that we can't consider constitution as also being the overarching protective mechanism for many countries. There are various provisions within the constitution that can actually impede reform of family laws, such as when we're seeing the Middle East, a lot of the countries have Muslim family laws that are based on Islamic Sharia and so on. And what this primarily means is that they're looking at interpretations of religious text through which the laws are then codified. So just to also say that there's a diversity of examples around the world where the Constitution is in direct contradiction to equality provisions even. And this hinders reform of and progress to achieving equality within family laws as well. The other thing I want to mention is an example from Malaysia. So what we're seeing from Malaysian context is that the Muslim majority communities, so Malaysia is a predominantly Muslim country. The family laws that apply to the Muslim majority communities are still stalling on reform. So they got reformed, and then there was, there were certain provisions that were taken back. And so it actually regressed in terms of reform. But reform for the for the non-Muslim community, non-Muslim minority communities actually progressed forward. So when it comes to family law, so when it comes to family laws in Malaysia, the non-Muslim minority communities actually have far more rights than the Muslim majority communities, because the barriers and challenges to reforming religious family laws is so many and so contested. And I think that those are really interesting juxtapositions in terms of, how minority communities and majority communities are affected based on what some of the pushbacks are from their own constituencies and political will of their own governments. Family laws affect women in their most intimate areas of their lives. And when it comes to, if family laws don't even have protection when it comes to marriageable age, so if it doesn't put age of marriage as 18 without exception, then we're also seeing family laws affect children of those communities or countries where the marriageable age or the age of marriage is less than 18 without exception. So it starts literally from childhood in those contexts. But otherwise, it really affects women. We're seeing that discriminatory family laws affect women in terms of entry into marriage. So consent, they're unable to consent to marriage. They sometimes need permission of male guardians to enter into marriage. So the autonomy to make a decision about whom to marry, when to marry, and entering into marriage as free will is taken away from them. We also see dowry practices. So a lot of the early stages of marriage is basically also contains a lot of dowry conversations, and therefore sometimes women are stripped away from their financial rights when it comes to what they can bring into marriage versus what is considered their husband's property in terms of what is given to them. We're also seeing impacts play out during the course of the marriage. So in many family laws, and I'm talking particularly about Muslim family laws, husbands are allowed to take, up to 4 wives, sometimes with conditions, sometimes with no conditions at all, such as the Sri Lankan Muslim Marriage and Divorce Act. It has no conditions for Muslim men to take multiple wives. And what this means is that women are not able to do not even need to know that their husbands are taking a second wife. They don't need to consent whatsoever. They have no say in what happens to their financial rights thereafter. And this has grave impacts on women and children, particularly in contexts where there's economic strife, where there's economic crisis, and so on and so forth. And we're seeing discriminatory family laws definitely play out at the end towards the dissolution of marriages, particularly when it comes to unequal divorce rights. We see the divorce process being much harder for women. We see women having to, bring in witnesses and bring in, evidence in order to leave marriages, but husbands can simply leave marriages, up at their will. And we're seeing access to justice issues, like significant access to justice issues for women, whether they're governed by community courts, whether they're governed by religious courts, or whether they're governed by civil courts. It's really difficult for women to access maintenance, to access divorce, to access custody and guardianship of their children, and definitely to access inheritance and matrimonial property. So there's discrimination from start to finish, if you want to phrase it that way. And what this means is that there's health repercussions, there is restriction when it comes to bodily autonomy and sexual health and reproductive rights. There is restriction and limitation when it comes to deciding to pursue education or employment, livelihood opportunities and access to resources, and so on and so forth. So the impacts of discriminatory family laws is starting from the home, from the family unit, has widespread implications. And one of the points I want to bring out very quickly is that we're seeing this sort of discrimination play out in a country's economic impact, right? So World Bank research shows us that many countries at the bottom of various gender equality surveys are countries with discriminatory family laws, which means that there is a country level impact of discriminatory family laws, you know, and thereafter there's human development and sustainable development goal impact for countries. So this is not an issue that is only affecting two people or an individual woman. This is an issue that is affecting countries and regions and the world globally.
I think the point, just as Hyshyama made, from start to finish in a woman's life, it's all discrimination, and the impact is felt throughout her life. So when you're looking at customary practices, for example, with regards to the age of marriage and the fact that the onset of puberty is in itself an indication in most communities as a girl being ready for marriage, and linking that to ongoing harmful practices such as female genital mutilation, then those then impact the life of a girl, not just socially, because then she has to stop her education in order to undergo FGM. With FGM comes a lot of sexual health and reproductive issues. And then she goes into child and forced marriage, meaning that by that time, which is usually at the onset of puberty at 12, the life of a girl then is cut off, you know. So she's not able to continue with her education. She's in a forced marriage. As a child bride, then she has to begin starting her own family. She's not ready to have children, but she's expected to take care of those children. And so this negative history continues to, you know, roll over even to her child. So we still have countries that have not set the minimum age of marriage at 18, which is what is prescribed by international and regional laws such as the Maputo Protocol. And this then means that, you know, children can get married before they are 18. In other countries, such as in Tanzania, we have different minimum ages of marriage. So in Tanzania, the law says that you know, the minimum age of marriage for boys is 18, and this is previously in the Law of Marriage Act. It was set at 18 for boys and 15 for girls, which could be even as low as 14 with the permission of the parents of the girl. Yeah. And so civil society organizations went to court supporting a lady by the name of Rebecca, who challenged this particular provision on the discriminatory minimum age of marriage for boys and girls. And she was arguing in that case that the minimum age should be equal for both boys and girls at 18. And the High Court actually agreed with her and indicated and ordered that the minimum age should be set at 18, meaning that the Law of Marriage Act needed to be amended in order to reflect the minimum age of marriage for both boys and girls at 18. Unfortunately, the government appealed that decision, but the Court of Appeal upheld the original decision. Now, even though the court had indicated, you know, in its decision that the minimum age of marriage should be 18, the practice is still that girls are still getting married at the age of 15 or 14, you know, in total contravention of what the court had ordered. But you also continue to see that, you know, where we have child marriage, there aren't any specific efforts by government to ensure that that they abolish, you know, child marriages, and so this becomes still remains a very relevant issue. But the other thing the other area in which we see discriminatory laws is with regards to even custody of children, where women are sometimes denied full custody of their children in the instances of divorce. But there are very progressive laws that have been adopted in countries such as Burundi, which you know, give the same rights to women as men with regards to legal guardianship of their children. The other area where we're seeing some trends in this regard are with respect to inheritance. So we still have discriminatory practices in inheritance of family property that are skewed against girls and women. Women still are not able to inherit the property of their spouses when their spouse passes on. This is the case in Burundi, for example, and in other countries as well. There's also the issue of gender-based violence, and in particular sexual violence when we are looking at marital rape. So quite a number of countries have excluded marital rape from criminal offenses. So whereas countries might have a Sexual Offences Act, they do make an exception with regards to rape occurring in a marriage. So marital rape is not recognized in a number of countries as being an offense. And this in and of itself, when you're talking about the impact on women and girls, means that they cannot even report marital rape, and no action will be taken because it's happened within the context of a marriage and it's exempted from the statute book. However, there are some countries, as I said, that have been very progressive and have actually indicated in their statute books the prohibition of marital rape, which is where we hope the other countries are also going to go to. And this, the exclusion of marital rape is in addition to already existing inadequacies within the legal framework to protect women from gender-based violence. So even in the broad context of gender-based violence, you don't have sufficient laws or institutions and systems to protect women against violence, or even to afford them justice when these violations are perpetuated against them. So then when you add marital rape onto that, it just means that the oppression against women is further exacerbated by the absence of these laws or the exclusion of marital rape as an offense. I think the other thing that we are also seeing is harmful practices that continue to happen within the context of families. So, for example, you have the ghost marriages in South Sudan, or you have widow inheritance in certain communities where a husband passes on and the brother of the husband then marries, quote unquote, marries the widow, and under the pretext of continuing the lineage of his brother. And so these are very harmful practices, especially when you look at it against sexual reproductive health rights, and especially with regards to the high rates of HIV infection, for instance. So we're still seeing these harmful practices continuing. The other thing that we note is that of course, there's the issue of divorce, but how and who can initiate divorce is different in some countries. So a woman, for example, might not be able to initiate divorce on the same grounds as her husband. You find that some countries require a woman to only initiate divorce in certain instances. For example, a woman would be required to prove more grounds for divorce as compared to a man. So it's easier for a man to initiate divorce than it is for a woman. And indeed, we do see that more men initiate divorce as opposed to women. The other thing, of course, is around inheritance of family property, where girls still are not able to inherit on the same basis as their male counterparts. A case in point is in Tunisia, for example, where a man can inherit twice as much as a woman. And so, that just means that already in the eyes of the inheritance laws and practices, Tunisia still views women and girls as being inferior Amen.
One example I want to bring out, just linking it to also child marriage and rights of girls, is this country of mine, Sri Lanka, which is currently going through significant reform of the Muslim Marriage and Divorce Act and other family laws at the very moment. And we're at the edge, hopefully, of some significant reform that will happen to family laws towards equality and justice, which is why it's really important for me to bring up this example right now. So what's really interesting is that Sri Lanka, the General Marriage Registration Ordinance did not have minimum age of marriage set to 18 without exception prior to 1995, right? So in 1995, after lobby from women's rights groups, after also political will from within the government to some extent, the General Marriage Registration Ordinance was amended, as was the Penal Code. Statutory rape provision was amended to protect women, protect girls, Statutory rape provision was amended, and the General Marriage Registration Ordinance was amended to raise the minimum age of marriage to 18 without any exceptions. Now, they did not amend the Muslim Marriage and Divorce Act, which meant that Muslim girls were not protected by the changes that happened to legislation in 1995 in Sri Lanka. And up to today, there is no minimum age of marriage in the Muslim Marriage and Divorce Act for Sri Lankan girls. And in fact, the Sri Lankan Penal Code, as according to the Sri Lankan Penal Code, sexual intercourse with a girl below the age of 18 with or without consent amounts to statutory rape. But because there was pushback from mainly Muslim religious leaders in opposition in 1995 when this was being amended, to get to this provision, the provision does not apply to Muslim girls who are married under the age of 16 and above the age of 12, unless judicially separated, which means that marital rape does not apply to anyone in the country, but especially even the statutory rape provision does not apply to married Muslim girls. So I think it's important to bring about that there are so many contradicting kind of examples of communities within the same country that are not protected by guarantees of equality, by the country's international obligations. There are so many exceptions simply because men or community leaders or individuals from within communities are pushing back on some of the key reforms. And I think it's important to raise that as highly problematic, because what that does is exclude women and girls from those communities for decades thereafter, right? So I think that nuance is really important to bring about. However, we're seeing progress on reform. And I think child marriage, particularly the minimum age of marriage when it comes to being embedded within family law discourse, but also legislation, is changing. Actually, we're observing that the most reformed provision, when it comes to family laws, is child marriage. So Philippines just recently, I think last year, raised their minimum age after quite a bit of lobby from women's rights groups, but also from women parliamentarians. Maldives raised their minimum age in 2019. Indonesia raised their minimum age in 2019 as well. So we're seeing quite a few countries progressing on particularly this issue, because it's very easy to say that this is a child rights issue, right? So it's a low-hanging fruit for many countries, and advocacy on it is very strong. But this stops when it comes to women's rights. This stops when it comes to marriage, and we're seeing that there's also hesitancy from within women's rights groups, particularly when it comes to religious and customary laws. Because we're yet to nuance the discourse that, that working on religious and customary laws in particular does not mean that we're taking away rights of religious communities or of, communities that practice customs and traditions and religions. We're not working towards that. In fact, we're working to protect those rights, right? We're working to ensure that communities, and particularly women and girls within those communities, their rights are protected when we reform discriminatory practices. So I think that discourse of religious rights, minority rights, customary rights versus family laws, because a lot of them, consider family laws as one of the key identity markers of their communities, has to be nuanced and has to be, discussed in much more detail, because we cannot conflate the two, and sometimes we end up kind of saying that if we reform family laws, we're denying customary or religious rights, and that is by far, the last thing that women's rights groups are intending to do. So, I just wanted to raise that as one of the emerging issues that's coming up in conversation when we talk particularly about discriminatory, customary and religious family laws.
I would say that 30 years ago, equality in family laws was one conversation that was still very elusive, still very unrefined, especially on the African continent. Of course, 30 years ago, we had countries ratifying CEDAW, so up in the 80s, for example, but they did so with reservations. So, for example, Malawi, when it ratified or assented to CEDAW in 1987, it entered two reservations. And most of these reservations were based on traditional customs and practices in Malawi. And so those reservations, meaning that, Malawi will say that they wouldn't be bound by the articles on which they entered reservations, were purely, based on the existing discriminatory traditional customs and practices. And so over the last couple of years then, and particularly within a decade of Malawi's ascension to CEDAW, they did lift those reservations in 1991. And now we can say, that Malawi has fully acceded to CEDAW and is bound by all the provisions of CEDAW. We had the same thing happening in Tunisia, for instance. They also entered reservations with regards to certain articles of CEDAW, but with years of reform in Tunisia, and particularly when it adopted its constitution in 2014, they lifted those reservations. So the trends that we then see, with regards to CEDAW as a key instrument is where countries had ratified CEDAW with reservations, they have over the years lifted those reservations. But more importantly, 30 years ago, we did not have a specific women's rights treaty in the continent, even though we had the African Charter, which is the primary human rights instrument. Here, it was very restrictive and had basically very little mention of women's rights in the family context. Article 18 of the African Charter on Human and People's Rights is the article that is primarily relates to family law. But in the way that it is crafted, it just speaks to general equality in the family, and particularly, says that women and children should be afforded the same rights in the family, and then it ends there. So there wasn't an expansive and comprehensive women's rights instrument over 30 years ago. But now in 2003, the African Union adopted the protocol to the African Charter on Human and People's Rights on the rights of women in Africa, that is the Maputo Protocol. And the protocol in and of itself really addresses itself to the complexities, the unique aspects of the lives of women in Africa. It also goes further to speak and to prohibit certain practices, such as child marriages. We're talking about setting the minimum age of marriage at 18, encouraging monogamy as the preferred form of marriage, even though it still does make provisions for equal rights of women in polygamous marriages. But more importantly, it also recognizes that harmful practices such as female genital mutilation are still rampant on the continent. And so the Maputo Protocol explicitly prohibits female genital mutilation. But it also makes very useful provisions with regards to equality before, during, and at the dissolution of marriage, especially when you're looking at the distribution of matrimonial property, the equality of parties, at the beginning and at the end and during marriage, when it comes to who can initiate separation or a divorce, annulment, whatever that may be, of that particular marriage. It also goes to say that the parties have equal right to the custody of their children. And so I think that in the last 30 years, we've seen, especially with lifting of reservations to CEDAW, and the adoption of the Maputo Protocol, we've seen a lot of progress on the continent. We've also seen, as I had said earlier on, a lot of law reform that then seeks to conform national laws to either CEDAW or the Maputo Protocol in particular. As we pointed out, raising the minimum age of marriage to 18 is one of those areas where we've seen incredible progress. But also when it comes to the African continent, and particularly within the documents of the African Union, speaking specifically to distribution of matrimonial property, there's a lot of guidance, from texts that have been adopted at the AU level that then give guidance to countries on how to address the issue of distribution of matrimonial property, for example. But we've also, over the last years, seen very intentional campaigns by the African Union. So, for example, there's a campaign on ending child marriage. There's a campaign on ending female genital mutilation, and all these just go to show that family law and the advancement of equality in the family is really advancing and progressing very well on the continent. That doesn't mean that we are out of the woods yet. We still, as I had pointed out earlier, we still have very discriminatory laws and practices, and those still need to be reformed. So to sum it up, over the last 30 years, significant and notable progress has been made with regards to ensuring that there's legal protection at the regional and international and national levels, but there still needs to be a lot more work to be done with regards to ensuring that then those laws make a difference in the lives of women and girls on the continent.
If I may add to that, just from a few other regions, we do not, the South and Southeast Asian region, as well as the MENA region, does not have a strong regional instrument like the Maputo Protocol. And I think that's highly problematic for us, but then that also makes CEDAW really the benchmark for women's rights, and obligations of nation states when it comes to gender equality. What that means, though, is that there has to be, and there is an emerging, as far as I've observed, an emerging women's rights movement, whether it's national level, regional level, from within these two regions that are really emerging when it comes to mobilizing on family law reform. So we're seeing the demand for, but also the interest and the commitment in making those intersectional connections between family law and SRHR, between family law and specifically the issue of child marriage, between family law and harmful traditional practices, and other kind of, key gender equality intersections, that there is a growing movement from within these two regions. And that is really, I think, quite different, and something that our generation, and generation before us really need to be proud of, because this is basically coming in the last 20 to 30 years, and more so growing now, because women's groups and women's rights activists have, I think, more data and more research coming out about family law and the impacts. There's a lot more of organizations that are working on this more intentionally, looking at this as an area of work, Equality Now included, Musawa, that 10 years ago formed to do this work on redefining Islamic jurisprudence through a feminist lens, but also now very focused on Muslim family law reform, and a few other organizations that are also looking at this as an area going forward with sort of like an intentional approach, right? And that's new. But what that also means is that we need to connect this issue to the issues of our time. We need to connect it to conflict and migration and some of the practices and laws that migrate with communities that move from their home locations, and how does that impact women and girls? We need to link it to climate change, access, and how the limited access to resources because of discriminatory family laws impacts women when it comes to the issues of climate change. So I think that those kind of other connections with global movements is happening. There are rumblings of it. We observed this in the Africa Regional workshop on family laws that just got concluded. And that is, I think, for me, the most kind of exciting thing. And I mean, last but not least, we also now have a global movement for equality in family law. 8 organizations came together to make this a priority global issue, to say that wherever we are, in whatever region it is, globally, this is an issue that needs a global eye, and an advocacy that is very much targeted, an advocacy that is very much focused on bringing this issue up at all various international forums. So I would say that the world is going to hear a lot more about family law, because there are groups and organizations and networks that are mobilizing throughout these regions, and there will be a persistent and a consistent and a very powerful call for reform of family laws, because it is vital and a crucial precondition for gender equality. And there is no other way of going about it other than some global action, which the world will see.